So the topic of today is long-arm jurisdiction, and long-arm jurisdiction gives the court power to award damages for infringement over defendants located outside its jurisdiction, and a similar power to award injunctions and or preliminary injunctions known as cross-border injunctions. In the Netherlands, the cross-border injunction was common practice and was invented in the 1990s, held by the so-called kort geding, the Dutch preliminary injunction proceedings. In 2006, the cross-border practice was restricted by 2 European Court of Justice decisions. There was Primus decision. The European Court of Justice did not allow for the spider in a web doctrine, and the cat versus luck, the European Court of Justice held that only the courts of the member state where the patent is valid have jurisdictions once validity is put in issue, irrespective of whether the issue is raised by way of an action or as a defendant's or counterclaim. So that took for some years, and in 2012, the European Court of Justice gave new life to cross-border practice. And because in the Solvay-Honeywell case, it was stated that if one or more companies infringe the same European patent with the same product in multiple European member states, the patent holder may be entitled to obtain a provisional cross-border injunction before the court of one of those countries that's applicable in all those states. And it's good news, since this year, cross-borders have been alive and kicking again, with the possibility of enforcing European and foreign patents in an efficient way in the home court of the defendant. In this case, BSH initiated proceedings against Electrolux before the Swedish court, stating infringement of its European patent being validated for certain European Union states all the time, at that time also including the UK and Turkey, and asking for an injunction. And Electrolux, the defendant, argued that the patents were invalid and that the court had no jurisdiction, as Article 24 of the Brussels regulation meant that if invalidity was raised, the court had no jurisdiction for the infringement. If you look at what the conclusion of this court says, is that defendants still need to challenge validity locally with regard to claims on the merits of different national parts of a European patent from another EU member states. The court confirmed that when a validity defense is raised, the court dealing with a cross-border infringement claim retains its jurisdiction, even if another court must first decide on the validity of the relevant national part. And the court ruled that an European Union member state court can rule on such a validity defense as long as it does not affect the existence or registration of the patent or any other amendments in registers of third states. So this means that EU courts have jurisdictions over cross-border patent infringement cases, regardless of validity challenges, when the defendant is located within the court state, or for UPC in one of the 18 states participating in the UPC. So more precisely, Article 24 of the Brussels regulation, the court held that Article 24, which grants exclusive jurisdiction over patent validity disputes to the national courts of the country where the patent is registered, does not stand in the way of infringement actions in other European Union states, even when validity challenges are raised as defenses or counterclaims in those actions. So this means that even for the non-European Union states, the court confirmed that Article 24 does not limit European Union Court's jurisdiction over patent infringement actions involving non-European Union countries, enabling claims to proceed for defendants located within the EU, even when the infringement occurs outside the European Union and validity is raised as a defense. So if you look at what happened is that the Court of Justice emphasized that the court of the member state can rule on the invalidity state defense, but that this decision can only have effect between the parties involved and will not affect the patent regarding third parties. So if you look at this now, what's exactly the meaning of this decision, what's the impact, then you can see that for the EU member states, it covers the home courts plus infringement countries. But it's also valid for other Lugano Convention states. That's for the other states, the EU member states, but also Switzerland, Norway, and Iceland. So then you can get a cross-border injunction. But also other European Patent Convention contracting states, including, that means all European Union member states plus non-European Union countries like the UK, Switzerland, Norway, and Turkey. So that could be qualified as an infringement country where a cross-border action could be taken if you have a home state in one of the countries of the European Union. And perhaps even further, well, decided at the court is maybe third non-European Patent Court countries can qualify as infringement countries. So the infringement court may stay infringement proceedings according to the Court of Justice in the BSH decision. An invalidity action has been duly brought by the defendant in that other member state. Infringement court takes the view that there is a reasonable, non-negligible possibility of that patent being declared invalid by the court of that other member state. So that means that the court, the national and UPC infringement courts have power over a possible suspension of the infringement action. And this reasoning of this case is a very important case that makes the cross-border injunction alive, does also apply to the UPC. We have already seen and discussed the Fujifilm versus Kodak decision, where the local division of Düsseldorf stated that the UPC can decide infringement action against German defendants also in respect of UK part of the European patent, but also recently in the Paris local division case, the multi-lock France IMC creations case. The parts in this case are EMC and multi-lock in multiple countries. And IMC filed a lawsuit at UPC to decide on infringement of their European patent. And multi-lock objected the jurisdiction of the UPC regarding Spain, Switzerland, and the UK because the countries are non-UPC countries. But it follows from the decision that UPC can deal with an infringement action against France and Swiss defendants. And this includes non-UPC states such as Spain and non-EU states such as Switzerland and the UK. It's also seen as the visualization of the PowerPoint presentation. And we have also another case is in the Milan local division, and it's another example. And this decision relates to a European patent which is validated in numerous UPC countries, as well as Spain, a non-UPC country. And there was also a preliminary objection in respect of Spain, but the UPC explicitly ruled that the Italian company Alpine Stars, located in Italy, being located in Italy, and the patent being valid in Spain, UPC has jurisdiction over the Spanish infringement claim. So I now coming to my conclusion. The UPC can rule on infringement of patents of EU member states that are not part of the UPC, for example, Spain, within limitations set out by the Court of Justice. If you look, so it's a really important decision, and we see that it gives a lot of power to the also UPC court to allow jurisdictions also in the non-EU member states. And I think that although the UPC court can suspend at the court, depending of when the defendant has started an invalidity action in another state, and the court of the UPC courts of the opinion that will be a very strong case, then it can suspend. But we expect that the UPC court will really allow such a cross-border injunctions as we have seen in the few cases we have discussed today. So this was the first topic of today, the long arm jurisdiction. The key point is that the cross-border jurisdiction was invented in the 1990s by the Dutch courts. It's a very strong cross-border practice, and we think that is totally back, and that the UPC can really use this powerful tool to also in the favor of the patent owners to allow also the cross-border injunctions. So I will thank you for listening to this topic, and now I will give the floor to Tilman from Meisner Bolte.